Hi, welcome. Thank you for joining us for the fourth in this 5 series of short webinars on misconduct dismissals. My name's Gary Smith. I'm a partner in the employment team at Knockhold Solicitors. And in this session, we're going to look at criminal conduct, something that adds an extra layer of complication to any misconduct dismissal. So generally speaking, there is no rule that says that simply because an employee is being investigated for criminal conduct, that they have been charged for criminal conduct, or even that they've been convicted for criminal conduct, there is no rule that says they have to be dismissed or disciplined, or you have to do anything particular about it whatsoever. The question is, does it affect their suitability to do the job? And how does it, the conviction or the charge or the investigation, how does that attach to their duties, their day-to-day responsibilities, and as the employer, your responsibilities to your customers and third parties, and of course, to other employees? We're often asked, well, can we proceed before it goes to trial? Because employees often go, oh, well, I'm being investigated, but I'm innocent. Oh, don't sack me until the trial. Well, you don't have to wait till the trial. You can still proceed with dismissal. And even if the individual, as we'll see a bit later, even if the individual is subsequently found not guilty, the dismissal can still be fair. The tribunal will look at the circumstances in the round. So they'll look at how long until the trial, and certainly the way the courts are at the moment, that could easily be 12 months or more. Can they undertake their duties before trial, or do you need to put them on some sort of suspension? The size and the nature of the business, obviously the larger the business, the easier it is for it to soak up the additional cost. And of course, the reputational risk to the business of continuing to have that individual associated with them as they're going through a very public criminal trial. But of course, it goes even further. If there's custodial sentence, it is still not automatic that dismissal will follow. Does the length of how long is the sentence? Does that automatically frustrate the contract? Was the offence related to their employment in some way? And again, does the case reflect on the employer's reputation? Now, in almost all instances, a custodial sentence will have a dismissal follow it because they're simply not able to attend work. But the point here is that it is not automatic. You still need to go through a process. You still need to lend your mind to the idea about how it affects your workplace and how it affects your reputation. So for example, and I've got a series there, a retail employee who was found shoplifting from another store, the dismissal was held to be fair because it's directly relevant to the trust the employer must have in them running their store. A teacher of children convicted of possessing cannabis, dismissal fair. Again, the duties to look after the children and to set the right standards. But then a teacher of adults convicted of possessing cannabis was held to be unfair because of the difference between the responsibility of looking after children and the responsibility of looking after adults is, in these instances, materially different. So you can see how certain convictions can lead to fair dismissals, but in the circumstances, almost exactly the same conviction can lead to an unfair dismissal. And so it is important that you always lend your mind to what is, how does it relate to work and what is reasonable. Even though they are going through the court process, even if they have actually been convicted or even sent to prison, you still need to follow a disciplinary process so far as you can, accepting, of course, that they may not be able to attend a disciplinary hearing if they are in prison, or they also have the right, of course, not to incriminate themselves for any future criminal trial. So you could find yourself in a situation where they simply decline to attend the disciplinary hearing or give you no comment answers. Your responsibility then is to make the best decision you can and to act fairly and reasonably in all the circumstances. And you can dismiss fairly if you have a genuine belief in their guilt based on reasonable grounds following a reasonable investigation. If they decline to cooperate with that investigation, then relying on the evidence you have becomes a lot more reasonable. Okay. So I hope that has been of interest. Our next webinar and our final webinar in this series on misconduct is going to deal with the particular circumstance arising cases of gross negligence. And I hope you'll be able to join us for that. Thank you.